I don't know if Mr. Potter or Mr. Brown are having their cases heard by Judge Keegan, but ex parte communications are frowned upon. You're putting the judge in a terrible position. He is not supposed to be talking to you if he's hearing your case. Outside of the court, I should say, without the presence of the prosecution. So if you wonder why he's not being terribly interactive with the with two of the three stooges, that would be a real good reason why. As far as the constitutional question, Mr. Potter asks, why can't you film the judicial branch if you can film the legislative and executive branches? Apparently he is unaware of the Fifth Amendment, which provides the accused with certain protections. But he also doesn't understand how things work. This is the United States Senate website, www.senate.gov. You'll see that prohibited items in both the House and Senate galleys include any battery-operated electronic device, except for medical devices, and cameras, both in and out of session. The White House, prior to 2015, did not allow cameras and compact cameras and smartphones. As of today, they do, provided their use does not interfere with other guests' enjoyment of the tour. But you still can't bring in any video recorders or cameras with detachable lenses. You can't live stream. You can't talk or text on your cell phone. So there are still rules against filming, at least in certain ways, in the White House. This all goes back. This is Hague v. CIO. This is the grandpappy, the originator of our First Amendment law. If you wonder why it took till 1939 to get it, I don't know. I just don't know. But this is it. This is where you get the traditional public forum test in its earliest form. Whatever the title of streets and parks may wherever the title of streets and parks may rest, they have immemorially been held in trust for the use of the public and, time out of mind, have been used for purposes of assembly, communicating thoughts between citizens, and discussing public questions. Such use of the streets and public places has, from ancient times, been a part of the privileges, immunities, rights, and liberties of citizens. The privilege of a citizen of the United States to use the streets and parks for communication of views on national questions may be regulated in the interest of all. It is not absolute, but relative, and must be exercised in subordination to the general comfort and convenience and in consonance with peace and good order. But it must not, in the guise of regulation, be abridged or denied. This is where you get the time, place, and manner restrictions that are allowable in traditional public forums. And remember, those time, place, and manner restrictions have to be narrowly tailored to achieve a significant or compelling, depending on the case you read, a significant or compelling government interest. So, for example, you can't use a bullhorn in a lot of places. You can't use a bullhorn in a residential neighborhood after a certain hour. That is a manner restriction. You could still talk on the street. You could use your voice, probably, but you can't use a bullhorn. So all of the rules they try to affect to limit your right of free speech and free expression in a traditional public forum there has to be a really good reason for it. And the rule has to be tailored to specifically target that narrow reason. The House, the Senate, and the White House and courts are not traditional public forums. They have not been, since time immemorial, used for the purposes of assembly, communicating thoughts between citizens, and discussing public questions by the public. Yes, senators are members of the public, but no, senators are a distinct class of people. They are not the public. All senators are members of the public. Not all members of the public are senators. The same thing with the White House. It's not a place where the public can go to express their views. Now, they can have sit-ins and protests and chants and marches, and they can picket and shout and howl at the moon on the sidewalk outside of the White House. But they can't do that on White House property. It's the fundamental error, it seems, in this community is believing that the First Amendment is some sort of a magic bullet. You can do anything you want as long as you're holding a camera in your hand. And that is simply untrue. All rights have limits. All of them do. You may agree with where those limits are or not. Some people may not want any limits at all, not realizing the consequences of that, but okay. But all rights are limited. And especially where the interplay of two rights come together, like your fundamental right to justice and a fair trial, your Fifth Amendment right to due process, where those come into conflict with someone's First Amendment right of free speech, one of the two has to give. You can't have both. And the courts have held that in a courtroom, the right to justice trumps the right to free speech. And a courtroom is not a traditional public forum. It's not a street. It's not a sidewalk. It's not a park. It's not a plaza. It is a non-public forum. So they don't have to use the time, place, and manner restriction. They could just have a legitimate interest, and that legitimate interest is the decorum of the court, its due process, its justice, its fairness. That's a legitimate purpose. And then they have to have a rule that is rationally related to it. It doesn't have to be a good fit, doesn't have to be a close fit, it doesn't have to be narrowly tailored. It just has to be related, rationally related to the problem that they're trying to correct. So anyway, I hope you found this informative. This is Hague v. CIO. This is a U.S. Supreme Court case. I'm putting it in the description so you can read it. You don't have to if you don't want to. But yeah, avoid ex parte communications with judges. Understand the Constitution if you're going to try to do a gotcha question on it. And thanks for watching. Have a great day.